welcome to my channel. My name is Diana Romanovska and I am a certified family law specialist practicing family law in the Bay Area. Today I would like to talk about limited scope representation. A lot of clients right now are in COVID-19 and unfortunately cannot afford full representation. And so a lot of the time they ask me, well, can you represent me just for custody or just for support or just for spousal support? And how does it look like? And the process for limited scope representation is defined, in case you would like to look it up, in California Rules of Court 5.425. And there are two types of limited scope representation. One type is undisclosed, meaning it only goes between me and the client. Opposing side does not know I am helping the client. Sometimes in situations where I had recently, for example, a husband is not willing to disclose the fact that he is talking to an attorney so that his wife doesn't get upset. It's personal choice, and so what we can do together, helping him, for example, just in custody matter, and help him to fill out forms and file a request for order for joint custody and visitation time. And that way, not only the other side, but also the court doesn't know that I'm there. The second part of limited scope, it's called limited scope representation, and it's disclosed to the other party and it's disclosed to the court. How does it work? The client signs a form FL950. It's a form that we can check off on what issues I am helping the client. It could be just for one hearing, it could be just for negotiation purposes. Anything is possible. So, and the notice of FL950 is mandatory. What is the consequence? The consequence is that the other side is not allowed to contact me for any other issues. They can only direct communication, for example, if I'm representing the client on limited scope only for custody, they can only contact me regarding custody issues. The consequence is that upon completion, the attorney is must fill out finding order after hearing form and whatever the judge ordered at the hearing, unless it specifically says in the notice of limited scope that this attorney is not going to prepare finding order after hearing. I'm not sure if you know, but in family court in the Bay Area, for example, in San Francisco, the court, when the judge issues a ruling, the judge typically does not prepare it. So the judge orders one of the parties' attorneys to prepare it. If parties are not represented, sometimes the judge prepares it because it's too complicated to explain to the parties how to do it. So, and then there are two options for an attorney to get out. One option is the client signs a substitution of attorney, a form MC050, or if the client doesn't sign substitution of attorney and the note in the scope is completed, the lawyer can send a notice of completion and blank objection to the client. Those two forms are 955 and 956. And 955 has another form that has information. It's called FL955 info. So if the client doesn't object within 10 days, then the lawyer can file the same form, FL955, the notice, and check off notice completed, the box. And then notify the court by filing it, serving it to the client again, and serving it to the other side as well. The first time we don't serve the other side, just the client, to see if the client objects. And then in case, in the first case, if client objects, the clerk will is required to issue a date to handle the objection and to handle related withdrawal from limited scope representation and to have a hearing. I hope that was helpful, and I will see you soon. Don't forget to subscribe and click like. Bye!